You're watching The Legal Breakdown. So, Glenn, we've got some major news here regarding a hearing that just happened today over Trump's efforts to get his illegal retention of classified documents case in Florida thrown out. And he's making that pitch, by the way, to a judge who is overly receptive to him. So, what happened at that hearing?
Yeah, so Brian, the good news is based on the real-time reporting that was coming out of the courtroom, it does not look like Judge Cannon is buying into these two motions to dismiss, one based on the Presidential Records Act and the other based on a claim that the Espionage Act, which was brought into existence in 1917 and has been used over and over and over and over again through our nation's history, is somehow unconstitutional. It is what they call void for vagueness, which is an actual doctrine. The problem is it doesn't apply to the Espionage Act. So based on what we saw coming out of the courtroom, unfortunately, there are no cameras, but there was a lot of great real-time blogging and reporting. It really does sound like Judge Cannon was having none of it. And this is why I love doing the legal breakdown, because we're going to kind of take everybody to a legal breakdown law school class here for a few minutes, because one thing in particular that Judge Cannon said is really important. And it highlights not only why Donald Trump's motion to dismiss is going to be rejected, it's going to fail, but it also helps explain why Donald Trump lies endlessly and consistently about things like the Presidential Records Act, letting him do anything he wants with records, and that the election was stolen. Judge Cannon inadvertently exposed why Donald Trump has to stick with those lies and has to stick with those cons. And just for a quick minute, I want to read a couple of sentences of what came out of that hearing today in that Florida courtroom. There was an argument that was made for a dismissal of the charges by Donald Trump's lawyers based on the Presidential Records Act. Here's what Donald Trump's lawyers argued. Presidents since George Washington have taken materials out of the White House. Now, that's entirely irrelevant because the Presidential Records Act didn't even come into existence until the 1970s. Let's set that inanity aside for a minute. The judge said that she was skeptical of the defendant's argument. She said, it's difficult to see how this argument that the Presidential Records Act lets you do it gets you to a dismissal of the indictment. But she added, this line of argument seems better suited to a trial or during jury instructions, but not a motion to dismiss. That's where your argument, quote, falters. Let's unravel that, Brian. So the Presidential Records Act does not let Donald Trump take presidential records. In fact, it stands for the opposite proposition. Records are the property of the people of the United States, of the federal government. They have to be given to the National Archives. So why does Donald Trump consistently lie and say the Presidential Records Act gives me a defense? It lets me do it. Here's why. There is a defense in the law called mistake of fact. Now, stay with me here. Donald Trump will not be permitted to stand up in court through counsel and argue to the jury, the Presidential Records Act lets me do it, because it doesn't. That's not the law. But here's what Donald Trump will be permitted to argue if he can present evidence of it. I mistakenly thought the Presidential Records Act lets me do it. So therefore, I lack criminal intent. I don't have a guilty state of mind. I don't have culpable mens rea. Mistake of fact is a recognized defense in the law, but here is how it can be used sort of effectively and persuasively. Brian, you and I are in a park, sitting at a picnic table. We have wallets that appear very similar. Yours is on the table, mine is on the table. When we leave, I pick up your wallet by mistake and I take it with me. Think about it. If I did it intentionally, it would be theft. If I did it mistakenly, what is it? Mistake of fact. So mistake of fact can actually be a defense to a criminal charge, but it has to be a reasonable mistake of fact, like the one I just laid out in the hypothetical. Now, let's change the hypothetical. I've got a $500 balance in my checking account. I go into a bank and I rob the bank of $5 million. And I say, I mistakenly thought I had $5 million in the bank. So that was my money to take. You can see how that would be a mistake of fact defense, and it would be laughed out of court. The jury would reject it instantly. Donald Trump cannot give up the lie. Donald Trump cannot give up the con. He has to keep saying publicly, the PRA, the Presidential Records Act, lets me do it, lets me do it, lets me do it, so he can retain the ability to walk into court and offer a mistake of fact defense. It will be an absurd and a ludicrous mistake of fact defense because that's not the law. And he's smart enough to be able to read the English language, let's assume, and understand that the Presidential Records Act stands for the exact opposite proposition. And all of his lawyers are advising him of that because none of his lawyers go into court and expressly say, yeah, the law is the Presidential Records Act lets our client take stuff when he was president. They don't even make that direct argument. That's why Donald Trump can't give up the lie, right? The byproduct of Donald Trump incessantly lying to the public about the PRA letting him do it is, yes, he's retaining a possible mistake of fact defense to offer at the time of trial, but he's also duping the gullible, his base, his supporters, MAGA world, into believing that is the true state of the PRA law, and it's not. The same holds true with his incessant lie about the election being stolen, because when he goes to trial in the case in DC for trying to overturn the results of the presidential election, he wants to retain the mistake of fact defense and say, oh, I thought the presidency, or I thought the election was stolen. That's why I did what I did. Well, no, he didn't, because all of his executive branch officials and agencies told him there was no fraud undermining the election's results. But, really, he's retaining a defense at trial, plus he just continues to poison the court of public opinion and fool the gullible into believing the two things that he consistently lies about. Thank you for sticking with me through that legal breakdown law school class.
No, I mean, it's super relevant and super interesting. But Glenn, isn't his mistake of fact defense completely and instantly undermined by the fact that the National Archives asked him to return those documents and even issued a subpoena to return those documents, and he ignored both of them?
Well, Brian, there you go talking sense. Donald Trump is not contending that he has a plausible mistake of fact defense, just one that he is retaining the right to raise in trial. Brian, I have had some of the most laughable alibi defenses offered up at trial, and I could easily defeat them, but that doesn't mean the defendant doesn't have the right to present it as sort of a last-ditch attempt to avoid criminal accountability for what he did. That is all Donald Trump is trying to accomplish. He's not trying to say he's going to have a winning defense. He just wants to retain the ability to use what little defense he has. And the minute he says, Brian, I acknowledge that the Presidential Records Act doesn't really let me take stuff when I leave the presidency, he has lost the ability of even raising that defense during his trial. That's why I predict until all of this is behind us, Donald Trump will be lying about the Presidential Records Act and the election being stolen.
Yeah, I mean, to your earlier point, even if he didn't have this defense to make in court, it still serves the purpose of poisoning the well of the public, and really that's what he's looking for at the end of the day, because he thinks it'll help him in the election by presenting himself as the victim at the hands of the evil deep state communist Marxist Democrats. Glenn, all of this kind of brings into light the possibility of Judge Cannon dismissing the charges on his behalf, even though you said that it's unlikely, given her demeanor in today's hearing, that she would do that. Can you talk about the benefit of the possibility, which still does exist, that she does dismiss this case, the benefit of her doing that as far as the prosecution's concerned?
Yeah, it's a strange position to take, especially as a former career prosecutor, that I'm almost hoping Judge Cannon dismisses the charges, because there is no basis in the law for her to do it. So what would happen if she dismissed the charges, just threw out the indictment? That would instantly be appealed by Jack Smith to the 11th Circuit Court of Appeals, and I can almost guarantee I'll put the full buck on the 11th Circuit reversing Judge Cannon, and that would give both Jack Smith and the 11th Circuit Court of Appeals all the ammunition they needed to remove her from the case, because it would be clear that she cannot be impartial. She's already abused her judicial discretion once before to Donald Trump's extreme advantage. And the 11th Circuit Court of Appeals reversed her and told her so, said you abused your judicial discretion and that you cannot interfere in ongoing Department of Justice investigations. I mean, that was more than one strike. That was really two strikes. She does it again to Donald Trump's extreme advantage and dismisses these cases, even though the law doesn't support it at all. I think that will be the last we see of Aileen Cannon as the presiding judge in Donald Trump's Florida federal prosecution.
Well, in your opinion, then, given the fact that she must know that she's setting herself up for the possibility of being removed from this case if she does grant that profuse gift to Donald Trump, do you think that it's more likely then that she won't dismiss the charges, but just keep handing Trump these little delays here and there that ultimately kind of, to that point, prove more beneficial to him than an outright dismissal would?
Yeah, she can kill this case by a death of 1,000 cuts or a death of 1,000 continuances to keep pushing the trial date down the road. A judge and a defense attorney can always find a reason to try to continue a trial. So it would surprise me at this point, hearing what she said in court today during the motions hearing, it would surprise me if she granted either of the two motions to dismiss. The Presidential Records Act, as we just discussed, she actually said in so many words, that dog doesn't hunt. In the context of a motion to dismiss, you may be able to raise a mistake of fact defense at trial, but that is not the basis of this motion. The second motion to dismiss was based on the claim that the Espionage Act was too vague. The Espionage Act has been used successfully over defense challenge to prosecute people like Julius and Ethel Rosenberg, John Walker, the Navy Chief Warrant Officer, Aldrich Ames, Robert Hansen. These are pretty famous names of spies and traitors over the years. And the law, the Espionage Act, has always withstood court challenge, and the same will be true here. There's very, very, very little risk that Judge Cannon will dismiss the Espionage Act counts in this case.
Okay. And now I have to ask this question for posterity here, but do we have any indication as to when we might have a decision by Judge Cannon as to when the trial date might be?
We have no decision on that. I didn't hear any reporting that she broached that subject today. The only thing I can say is at the end of the hearing today, she said that she will issue her rulings promptly in this case. Now, does promptly mean tomorrow, a week, a month? We don't know with Judge Cannon, but we still have no trial date. We have no prospect of a trial date. And the last we heard from Judge Cannon, she didn't like July 8th or August 12th. July 8th was suggested by Jack Smith and his prosecutors. August 12th was suggested by Donald Trump. You think that would have been an easy call. She could have said, I'll give Donald Trump what he's asking for. Trial date set for August 12th. She said, I don't think these dates are realistic. That right there, Brian, is an indication that her impartiality can reasonably be questioned, because when you reject as somehow not appropriate a trial date suggested by the defendant in the case, it feels like you're kind of playing for one team rather than calling it right down the middle. But to answer the question, no trial date in sight.
Well, it looks like Trump certainly got his money's worth with this appointment to the bench here. So, of course, we'll stay on top of this trial as soon as we have any updates. For those watching right now, if you want to follow along, please make sure to subscribe. The links to both of our channels are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.